Informed. My name is Carl Buhariwala, and I founded Be Informed to help people make decisions. Before I proceed, I would like to acknowledge the traditional owners of the lands on which we meet today and pay my respects to their elders, past and present. Today, we're looking at residential tenancies and what this means for you in Victoria. And we're joined today by Louisa Ewart of SLF Lawyers, who will be talking to us about residential tenants' rights in Victoria. So as you can see, we'll be looking at the Victorian jurisdiction today. So if you do rent a property in another state or territory of Australia, you may wish to consider the applicability of these laws because they might not be directly relevant to your jurisdiction. The information presented to you in today's seminar is current as of the 15th of August. So if you do rely on this information in the future, you may wish to consider its currency and relevance, given laws do change. The information presented to you today is of a general nature only. So if you do need any specific advice or help, please do reach out to a professional such as Louisa, who can then answer your questions and provide you with more specific and tailored advice based on your circumstances. So in terms of housekeeping, seminar will take about 25 minutes, followed by some Q&A. And if you do have any questions, feel free to share them with me through the chat function, and I will then relay them to Louisa. There is also a one-page handout, which Louisa has kindly prepared. So you will receive that if you have registered by email. And the session is recorded. So if you have to drop out or come and go, that's fine. You can watch the entire session online on our YouTube channel at your leisure. So with all those housekeeping matters in mind, and if you have any other questions, just feel free to let me know in the chat function. But without any further delay, Louisa, I'll hand over to you to start with the seminar.
Great, thank you for that, Carl. So to set the context of where we are currently at, in March 2021, a large number of amendments were made to the residential tenancy regulations. These largely aimed to increase the minimum standard of residential rental properties across Victoria and to ensure that tenants were being provided safe housing. These changes are a part of a collective and gradual move to better protect the rights of tenants in Victoria. And although these amendments and the broader shift which has occurred has in part achieved this, the current rental market is again favouring rental providers due to the sheer number of Victorians seeking to lease homes at the moment. This, combined with the increase in investors leaving the investor space, will likely mean this housing shortage for tenants will continue on in the immediate future. That's why we're here today, to help you better understand your rights to protect yourself in the current rental market. By way of background, I am a commercial lawyer and I have experience dealing with tenancy disputes. Prior to working in the law, I worked within the real estate industry for an agency and dealt with many tenants and rental providers on a daily basis and assisted in resolving a range of complications which can arise during a tenancy. So moving on to the boundaries of your residential rental agreement. To understand your rights and obligations as a tenant, you must first understand the terms which govern your residential rental agreement. Your residential rental agreement is regulated by the Residential Tenancies Act. It's also regulated by the Residential Tenancies Regulations. And as determined in the Act, if your residential rental agreement is contained in writing, it must be in the approved form. And this is set out within the regulations within Schedule 1, if you would like to have a look at it. These pieces of legislation and the written rental agreement collectively form your residential rental agreement. The significant changes which I referred to earlier, which were implemented in March 2021, are set out in Schedule 4 of the regulations. These set out the minimum standards for properties being leased in Victoria. And these minimum standards include, amongst many things, that the property must have fully operational locks on all entry doors, bathrooms must be in good working order, laundry facilities must have hot and cold water access, and each room within the property must be mold free. When you enter your rental agreement, you will likely be provided with a condition report. A condition report becomes a very crucial document within your tenancy. It will form the evidence which supports or undermines the return of your bond, which we will discuss a little bit later. The condition report should go through each room and appliance in the property and state its condition as at the date of you moving into the property. You should be provided 2 copies, and then you complete them and you must return them within 5 business days of moving into the property. That time frame is very important. If you do not provide a completed copy to your agent or rental provider within the time required, you can be taken to accept the copy which was provided to you by your agent or rental provider. It is encouraged to be very thorough when completing your condition report when moving into the property. We encourage you to take photos of any items which are damaged or used to record the state of them at the time you moved in. Ensure these photos are provided to your agent along with your completed condition report. It's at this time that you can compare the property while thoroughly inspecting it to the minimum standards set out in the regulations to ensure the property is up to standard. Ensure you keep a copy of the condition report and any photos which you took of the property at the time you moved in. Do not rely on the agent or the rental provider to hold on to this material for you. On completing the condition report, you can request for any defective appliances or any necessary maintenance issues to be addressed. Now moving back to the terms of your rental agreement. If any terms which are included in the written rental agreement are inconsistent or contrary to the rights and obligations in the Act or the regulations, they will be void, meaning that they're ineffective to the extent that they seek to reduce any right or obligation under the Act and regulations. This means that your rental provider and agent cannot try and limit your rights which are available to you. If you do identify any clauses within your rental agreement which are contrary to the Act and regulations, you should raise this with your rental provider or managing agent, ideally in writing, and just flag it with them and ask them to address it and correct it. So now we will move on to the breakdown of some of the terms within your residential rental agreement. Firstly, the obligations in relation to the security bond. Under a rental agreement, the rental provider can request a bond, which is monies that the tenant will pay to secure the performance of their obligations under the lease. This includes things like payment of rent, obligations to reasonably look after the property and not damage it, and possibly maintain and care for the garden. Pursuant to the Act, the rental provider cannot seek a bond which is in excess of 1 month's rent unless the bond is over the prescribed amount, which is currently $900 per week, although this is due to change at the discretion of the authority, or unless they obtain an order from VCAT allowing them, for a certain reason, to obtain a bond in excess of 1 month's rent. A bond obtained by a rental provider must be held by the authority. The authority is known as the Residential Tenancy Bond Authority, and the rental provider must provide the bond monies to the authority within 7 days of receiving these monies. On termination of a rental agreement, the tenant or the rental provider can apply to the RTBA, so the authority, for the return of the bond. All the parties can agree for a certain amount to be paid to the rental provider in compensation for any monies that the tenant may owe to them. If your rental provider is seeking to make a claim on your bond and you do not agree with the claim they are making, the next step is for one of you to make an application to VCAT. If you believe that a certain amount of money may be owing to them, but not the full amount of their claim, it's encouraged that you negotiate with them and engage with them to try and reach a mutually agreeable outcome. This will avoid the need for lengthy VCAT proceedings and hopefully save both of you some time. If the rental provider is seeking to claim more of the bond than you believe they're entitled to, you will need to follow the usual VCAT process. The RTBA cannot release the bond monies while there is an ongoing dispute in relation to those monies. During any VCAT proceeding, which deals with bond disputes, the condition report that you completed on entry will become very important. The rental provider will likely produce to VCAT your completed condition report and also an outgoing condition report, which they completed after you left the premises. VCAT will essentially compare the state of the property in your completed condition report, along with photos which you provided to your rental provider and managing agent, to the state of the property at the time you exited it. It can be as detailed as going through each room and each item in that room and reviewing things such as sections of flooring which may be stained or scratched to determine any monies that may be payable to the rental provider. All costs which are claimed against your bond must be reasonable, and VCAT will assess things in a reasonable light. Another common source of disputes between rental providers and tenants is rental increases. If a rental provider seeks to increase the rent, they must issue a notice at least 60 days prior to the proposed increase of rent and state on the notice the increased rent, the commencing date, and how the increase was calculated. An increase cannot occur during a fixed term rental agreement unless it is specified in the rental agreement. So these notices will usually be issued during a month-to-month lease. A rental increase can also not occur within 12 months of a previous rental increase for the same tenancy. A notice of rental increase will be served on you if the rental provider proposes to increase the rent. If you disagree with the rental increase which they are proposing, you can request Consumer Affairs to investigate the rent and complete an assessment. Consumer Affairs will look at the market rental value and determine if the proposed increase is too high. You must request Consumer Affairs to complete this investigation within 30 days of receiving the notice of rental increase. At the end of the rent assessment by Consumer Affairs, they will provide you a report which allows you to negotiate with the rental provider or proceed to VCAT, where you can make an application and seek an order for the rent to be set at market value in line with the determination by Consumer Affairs. As a tenant, you hold many rights, and it's important to know the avenues or methods you can use to enforce these rights. So now we move on to considering how you can protect your rights as a tenant. A common problem faced by tenants is having your agent or rental provider attend to repairs and maintenance issues throughout your tenancy. This, along with many other issues, are to be dealt with in the same manner. The first step when faced with a dispute is to issue a correspondence to your rental provider detailing what issues you are facing and what you are requesting them to do. Make it very clear. This should be done via a formal email or letter. And where possible, use the resources available, which we will discuss later, to reference any rules or regulations you can locate which evidences their need to attend to the items you are requesting. In the event no response is received or the rental provider and agent do not take sufficient action in response to your request, the next step is to issue a notice of breach of duty to your rental provider. This is done under Section 208 of the Act, and a template form can be obtained from Consumer Affairs Victoria. A notice of breach duty can be issued for a variety of reasons. Some include the premises not being left vacant or reasonably clean on your due move-in date, the premises not meeting the minimum standard requirements set out in Schedule 4 of the regulations, including external doors not locking properly. But there are obviously a variety of reasons that you could issue such a notice. On this notice, you will need to detail the loss and damage that their breach is causing you and the time within which they're required to remedy this breach. If you review the standard template form provided on Consumer Affairs Victoria website, that will point you in the right direction of how to determine what the required time is for them to remedy their relevant breach in your circumstances. Hopefully, on issuing a notice of breach to the agent or rental provider, they will attend as needed and remedy their breach and provide a satisfactory response to you. However, in the event these matters are still not resolved, you can then proceed to VCAT. Depending on your desired outcome, you can also report the agent or rental provider to Consumer Affairs and ask them to investigate the matter. It should be noted that tenants cannot be reported to Consumer Affairs. This right is only available to you as the tenant. To proceed to VCAT, you'll be making an application for orders, which can seek a variety of things, including compensation for your loss and damage, or for the rental provider to perform certain things such as fix items within the property. As mentioned earlier, you can also seek orders such as the rent being set to the market value. You may seek legal advice in drafting your documents to commence proceedings in VCAT, or you can undergo this process without legal representation. If you are facing an issue, it is best to first understand your position and entitlements. This can be done by accessing useful resources. There are a lot of helpful resources available to tenants at no charge. Firstly, there is Tenant's Victoria website. This provides details on rights available to you and provides answers to a lot of frequently asked questions. It also provides an overview for each step throughout the tenancy and common problems incurred. So this is a great resource to utilize, not just when things don't go as planned, but to use before you enter into an agreement so that you can fully understand all the obligations and expectations that you are taking on as a tenant. Consumer Affairs website is also another great resource, and they also have a phone line available where you can make inquiries. It again provides an outline of your rights available to you and also the processes which must be followed by the parties in the rental agreement. They also provide really helpful template forms that you can use and also examples of the set forms that rental providers need to provide to you in certain circumstances, such as a notice of rent increase. There is also information on when to seek the assistance of Consumer Affairs, such as asking them to investigate a rent increase and how their investigations will help you. The RTBA online is the Bond Authority's website. They provide a variety of information in relation to bond monies being held. So they also detail on there how you can have your bond monies returned and the processes you need to follow. And finally, VCAT website is another resource that is available to you. If you're looking to make an application against your rental provider or managing agent, the information on the VCAT website will show you the process of lodging such an application. It will explain the material you need in support of your application. And they also have a phone line available where you can seek updates as to the progress of your application or ask questions about any orders that are being made or what is required of you throughout this process. So I hope that was useful to all of you, and there's something that you picked up which you can utilize to better protect yourself and resolve any disputes or issues that you may face throughout your tenancies.
Thank you, Louisa.
Thanks, Carl.
And just sharing on screen Louisa's details there. So if you do have any questions or would like to specifically ask Louisa a query about your circumstances, then feel free to reach out to her directly. Her details will also be available in the one-page handout. So if you read my email for this session today, you will get that handout so you can keep it on file and you can use it for yourself or share it with those that need it, who are also tenants or potentially future tenants. So just as a reminder, this session is being recorded. So if you have joined late, that's fine. You can watch the entire session on our YouTube channel following the closure of today's session. And if you do have any questions, just send them through to me in the chat function, and I can relay them to Louisa. So what we'll do now is we'll get straight into Q&A, and Louisa will start off with some of the questions that we received ahead of time.
Yeah.
One of the themes that I want to draw upon, I think, is just, and I've received a few in relation to this, I'm just going to sort of bundle them together and we can have a chat about it, but it's in relation to international students and those on visas. And some are sort of, getting worried about potential situations where rents are going to go up or they're coming to the end of their term. Probably not a strictly legal question, but the questions that I've got, Louise, is just around what active steps can they take to negotiate with their rental provider so that they can get comfort with some longevity of their sort of housing circumstances. Do you have any sort of thoughts on that?
Sure. It's a really topical issue, I believe. So it's really important to flag at the beginning that international students or people here on visas have the exact same rights available to them as local tenants. So all the same avenues are available to you. If you're wanting to negotiate to secure a longer tenancy or more security, I think it's really important to contact the rental provider, explain your circumstances, and put forward a proposition to them, say where you sign on for longer than 12 months if that's what you're seeking. It is common that if you want to sign on for more than 12 months that you may need to pay a slight premium, because under a usual lease of 12 months, the rental provider would be entitled, as we discussed, to increase the rent at the end of that tenancy. So it's just something that you need to consider, but I think there's definitely benefits available to both parties. It would provide you security, but it would also provide the rental provider security, knowing that their property is going to be let for longer, and they won't have any periods where the property is vacant whilst they try and find a new tenant to take over.
Cool. So yeah, just summarizing that just because you're on a visa or you're an international student doesn't give you any lesser rights. You can still access
Definitely.
resources, the avenues, and exercise the rights that you have under your agreement, and also the broader legal protections that you are available to use.
Yes, and I should note Consumer Affairs has a whole page dedicated to educating international students or people on visas. So I imagine that if you reached out to them by phone, they would definitely be available to answer any questions or issues that you're facing, and they would have information available for you.
Hey, Louisa, you still...
Sorry, did I just drop out?
Yeah, are you still there?
Yeah.
Can you hear me?
Yeah.
Okay, cool. All right. I think I just had trouble. I think Cisco just had a bit of a drop there. I think, did the slides drop off the screen? Let me just reshare them. It was just a bit of a glitch. Can you see the slides back on screen? I'll just go back to the Q&A section.
Yeah.
Were you able to complete that answer that you had, the additional point? All right, cool. That's all right. It'll still have recorded in the background. Okay, so thank you for that. The next question that we've got, Louisa, is just around the bond. And potentially if this individual here has received sort of a claim against them, and you've sort of mentioned sort of the steps that you can take to sort of detail the response back. Are there any sort of rules of thumb that need to be followed just generally when preparing a response back to a landlord's request for a bond claim?
So first of all, they will need to make a claim to the authority. At that time, you can either engage with them and try and come to an agreement and negotiate, and the parties then submit that agreed amount, which will be paid to them to the authority. If you can't come to an agreement together, then they will need to proceed to VCAT to make an application. And that's where they will need to provide a lot of detail around the claim that they're seeking. So if they're seeking costs for any damage caused to the property, then they will need to, go away and obtain quotes to rectify that damage, and then you will have a chance to respond. It is important to note that when rental providers are making a claim to rectify items within the property, if, for example, there was damage to the carpet and the carpet was 7 years old, they are not entitled usually to the full amount of the brand new carpet. So they can't claim 100% of replacement costs. It needs to be reduced to a reasonable figure to consider, the usual wear and tear that was already present and the general age of the item that they're seeking to fix. So I hope that answers the question, but one, you need to either engage in correspondence with them to resolve it by agreement and then submit whatever the agreed figures are to the authority, or two, you can, if they are not proposing to come to a reasonable agreement and their claim is unfair, then you can tell them that they need to go and make an application to VCAT for the monies that they want to claim.
Yeah. So I think it's very crucial, just off the back of that question, I think it's very crucial that during that, what was it, Louisa? Was it 3 or 5 days that they get once the condition report is being sent to them at the start to really spend, how many, 7 days was it, or
It was 5 days.
5 days? Yeah, I think really using that time well,
Yeah.
to actually go through the, probably with a fine tooth comb, I guess, just to make sure that you really document the existing condition, right?
Yeah, and it will
Um,
really make it a lot easier when you vacate, because then both parties are clear what the state of the property was.
yeah,
Sometimes a rental provider might try and claim items, not to take advantage of you, but because they haven't been in the property for many years and they don't know the state of the property. And so all they understand is that you've now left the property and there's damage to certain things. So if you have a condition report completed from when you enter the property and photos to support that, that will really help your position.
sure. There's one question here just around sort of the role of the agent. Of course, the agent is engaged by the landlord or the rental provider, right, to
Mm-hmm.
I guess manage their property and the leasing arrangements. This question, basically, this individual is asking, can they help? Can the estate agent help, or should the renter be relying on someone else if they need any additional support?
So I think that's a really interesting question, because your agents do have an interesting position. They are obviously engaged by the rental provider, but for a successful tenancy, they need to engage with both parties and try and resolve issues that come up so that people don't end up in difficult situations. So I think if you are facing an issue, correspond with your agent and outline what the issue is that you're facing and what you're expecting them to do, or the rental provider to do. And if they if they say that things will not be actioned, ask them to explain. And I think you can use them to try and overcome any issues that you're facing, because their role is to manage the tenancy.
Yeah. So I think they're definitely a resource that you can use without, I guess, being fearful of who they are
Yes,
truly
definitely.
for. But they, I guess, I think you're right, they do have a vested interest in making sure that both parties, I guess, are happy, because without one party or the other, you wouldn't have, a proper arrangement, would you?
No.
Um, so definitely they go hand in hand. So yeah, definitely. But if you do need any specific, I guess, advice or support, then you might want to consider a professional, maybe a
Yes.
lawyer, or other, depending on your needs and circumstances. Thank you. The next question that we've got, Louise, is around subleasing, right? So I guess I'm a bit concerned around how apparent they make the arrangement, given I think there are rules under the law. So if you could just, and maybe the contract, if you could just sort of summarize sort of the position, I guess,
Yep.
around the tenant's ability to sublease, and
Yeah,
how they
sure.
should be doing that in a proper manner.
Sure. So with subletting, I will focus on usual residential properties being let, because if we move on to talk about rooming houses or uh, other types of properties, it becomes a bit more complicated. But if you are in a rental agreement for a standard house and you are leasing the whole property, you are able to sublet the property, but you do need to obtain the permission of the rental provider. Now, the regulations say that the rental provider can't unreasonably withhold their consent. But then it becomes difficult, because who's to determine what is going to be unreasonable grounds? So that will really depend on your rental provider and the position they take. If you think they are unreasonably withholding their consent and they don't have proper basis, you can make an application to VCAT for orders. If you are going to sublet your property, to do it via the proper methods, you should notify your rental provider. They will likely want to know the details of the person who you're subletting to. But it is really important to remember that you are still on the lease. So you are still liable for any damage or any loss caused to the rental provider during your tenancy at the fault of yourself or at the fault of someone you are subletting to. So subletting can seem like a good option sometimes, but it does come with a lot of risk, I suppose. So I hope that answers the question.
Yeah, no, that does. Thank you. So I think you just be mindful of it. You're subletting it too. You might be, definitely going to get paid for doing that. That's the purpose of doing it, right? But just be mindful of how they treat your property, and they don't sort of discourage you, I guess, from doing it in the future if they don't uphold your rights.
Definitely.
Yeah. Okay, and around just another question that we've got around condition, right, and the bond, and you mentioned, Louisa, of course, that if the landlord's making a claim, they'll need to substantiate it.
Mm-hmm.
Can the renter respond when it's when it's at VCAT, I guess, or when they're in discussion with their view of what the potential, they probably acknowledge, okay, there's some loss here, but they don't see it to be as excessive as what's being claimed. Can they also prepare their own submission, I guess, with their views and their potential quote to repair? Is that possible?
Yes. Yeah, absolutely. So when a application goes to VCAT, the person making the application, so in this case, it would probably be a rental provider, needs to detail what they're claiming and why you're liable for it. So if it is to repair, so say the paint in the property was damaged and they need to repaint 3 of the rooms and the floorboards were scratched, they will need to show that the property wasn't like that when you moved in, it was like that when you moved out, so you're most likely liable, and they will need to show the amount that they're claiming and why they say it's that amount, which would include quotes from various trades to go in and complete the remedial works. You then have a chance to respond to their claim. So you put in your own points in response, and that can include obtaining a comparative quote from other trades which you contact, and if it's of a lesser value, explaining that no, the applicant's claim seems to be inflated. We think these remedial works will only cost 50 to 70% of what they're claiming, and then that goes to the members in VCAT to consider.
Yeah, so you can justify if you think that their claim is excessive or, I guess, exaggerated, or
yeah, definitely,
they've broadened the scope of what might be remedied. So yeah, don't lose hope if you do get those letters or those claims. You can always
definitely
provide your own view. Definitely, yeah. Cool. And final question that we've got is just around the rent, the value of it. This individual is asking, okay, I'm planning to rent a property, and I can see previously what the rental amount was because it was advertised, right? So you can sort of see there, and then they're doing the math and they're realizing, well, this rental provider is now releasing it at a higher amount. Are there any protections for individuals that are renting for the first time? So you got the rental increase protection, so that's happening, I guess year on year or time period. But for those that are starting off and then they're looking back just on, because information is so vastly available, I guess, on realestate.com or Domain or wherever they're looking, they
Yeah.
can see that clearly the previous amount was substantially lower. Or is there anything that they can do at the start, or does the landlord get a clean slate, I guess, and can just set whatever the rent they want? Is there anything that they can do to challenge that initial amount, or do they have
Yeah,
lesser bargaining power at that starting position?
it can be a difficult position to start with, especially if you haven't rented before. You may already be finding it difficult to be approved for properties because you have no rental history. And so there is a slight power imbalance, unfortunately. What I would recommend is going on to websites like the REIV, realestate.com, Domain, and looking at the information they provide. So most of those websites will provide you an average rental price for different types of properties within all the suburbs. And so you can use that to gauge what's a reasonable market value as at today. Looking at a price that the property was leased out at, say, 12, 18 months ago, it might not give you an accurate representation of what it's currently worth. But if you think the property is listed at a price which is too high, I would suggest going to the managing agent or going to the rental provider, giving them the information that you've collated from the various websites, and just say, hey, this rent that you're seeking seems quite high. This is the rent I would propose, and see what they say. Although this information is advertised online as if it has to be accepted at that price, rental providers will negotiate if the market is not willing to pay what they're seeking.
Yeah. I guess there's no harm in asking, right? So I think to your point, you can ask, you can substantiate, and you might win. You might be able to successfully negotiate a lower amount. You put the effort in, you have a good chance. Of course, if the market's aligned with that sort of thinking as well. And actually, just a quick one has come through, Louisa. The question is, I am renting with my partner. Family from overseas are planning to come and join us. Is there an issue if we have family also living in the property that we are renting, but it's just me and my partner, I guess, that are on the lease?
I think you would need to consider in that circumstance if there is appropriate space within the property. So you're not able to allow an inappropriate number of people to reside in a property that you're renting. And you would also need to consider if it's an ongoing arrangement or if they're merely visiting for a few weeks. And if it was only for a few weeks and there was appropriate space, I don't imagine that there would be an issue. However, out of an abundance of caution, it's probably best to just flag it with your agent and note that you're just doing it, to ensure that no issues arise, and make sure that they don't take any issue with it. But if you had appropriate space and it was for a short period of time, it shouldn't be an issue.
Yes, I think that the takeaway from that is just communicate, right? Just let the agent know and ensure that everyone's aware of those circumstances without sort of doing it undercover, I guess. So cool. All right. Well, that brings us to the end. There's no further questions that I can see. Louisa, thank you for presenting. Her details are on screen, so if you do want to ask her a question or engage her for any sort of advice, you can contact her directly. And her details will also be in the one-page handout, which she has kindly prepared, and I'll email that through to you shortly for those that are registered by email. So you'll get that one-page document to have handy with you. That brings us to the end. So just a reminder, this session is being recorded. So following the closure of today's session, I'll post it straight onto YouTube so you can watch the entire session if you missed it, or if you want to share it with family and friends, you can just send them the link and they can watch it at their leisure. Yeah, we be informed, of course, so we strive to help people make good decisions, and we rely on word of mouth. I founded the organization myself, and I also run it and fund it myself, so it's all just me, and that keeps it impartial, objective, and independent of any private or public organization. So if you do wish to let other people know, or if you found this interesting, please do tell them to follow us on the social media sites there, or they can email us if they have any topics they would like to get covered in a future session. We're always open to suggestions. So that brings us to the end of the formal session. Our next session will be on, I think it is the 11th of September, which is a Wednesday, and that will look at quality management and having a customer focus in quality management. So it's mainly focused targeted at small businesses and medium businesses who are wanting to improve their customer experience. So thank you all for joining today, and thank you, Louisa, for your time.
Thank you.
And hopefully you've learned something, and till our next session, have a nice day, and enjoy the night for what it is. All right. See you all. Thank you, Louisa. Bye.
Thank you.